Guys, welcome. Today we're going to be talking about retrenchments. What happens when you're retrenched? We spoke a bit about the process of retrenchment last week, but we are going to touch on that again today because the whole idea is to understand what should happen and to recognize it when it doesn't happen, so that you know whether or not you've been treated fairly or unfairly, in order for you to understand if you even have the right of referral to the CCMA. So I always get into trouble for this. My name is Grace. I'm from LUMA Law. Please check us out on our Facebook page. Our page is Hi LUMA Law. We also have a chat bot there that you can just send us a hi and check out a lot of really good information. A lot of the stuff that we talk about here is available actually on the bot. So when you're not seeing us live, you can always find us there. I am here with my favorite people, my esteemed panel, Kgomotso, Mokoena, and Jermane, Mopp. I'll introduce them. Yes, it just feels like we do this every time, but I mean, there's always new people every time. Kgomotso is a lecturer at UJ. Her focus is on labor law. She's been doing this for a long, long time, over 10 years now. Not guessing people, over 10 years now. And we've also got Jermane Mopp, who is with us here to answer a lot of our UIF queries and also contribute to a lot of the labor conversations, because I mean, a lot of people, it's back to work now. Like I'm back to work. There's a lot of hand sanitizing to the point where you're actually not sure like which sanitizer to use. You know, people are spraying my feet, spraying my clothes, and it's just one of those things. But I think I'm lucky because at least we've got the whole social distancing thing going on. So these are things that we need to talk about. But I mean, it's not for today. For today, we're talking about retrenchments. But guys, as you know how it works, you're welcome to send us your questions through as we are going through the webinar. Sorry about that. And you are welcome. We'll be going through the whole Q&A session. You're welcome to stop us. You're welcome to raise your hand, and Chipo will unmute you and we'll take it forward. So I'm gonna let Kgomotso introduce herself again properly, and Jermane, and then we'll get the show on the road.
Okay, hi everyone. I'm Kgomotso Mokoena. I'm an attorney and an academic at the University of Johannesburg, and my primary focus is on labor law.
Hi everybody, my name is Jermane Mopp. I've been dealing with UIF for a long time, and then I'm currently pursuing my master's in labor law. And you guys are going to get a wealth of knowledge. One thing I want to indicate to you guys as the viewers, you make sure you have your legislation available. I got mine. I got the Basic Conditions of Employment Act here with me. I even got the Constitution here with me.
Jermane, people don't have those things with them.
You have to start buying it. This thing is not expensive. It's like 100 Rand or 150 Rand. This is the Employment Equity Act. This is the Labor Relations Act. These things are supposed to have if you're going to be able to defend yourself and know what you're talking about. To have these things in this, and then notice, I also bought me recently the Occupational Health and Safety Act. So I'm familiarizing myself with that. You see, this is pocket-sized books that you can have and travel with you at all times. So we'll have this. We will be sure to deal with all of your labor-related questions.
As you can see, we are ready for you. To get us started, guys, the whole reason why we're here today is because it's no secret that a lot of people are experiencing retrenchments, and a lot more people are going to experience retrenchments because of COVID. A lot of employers are running away from the responsibilities that have been put upon them by the law to follow specific procedures when it comes to retrenching people. So we just want you guys to know what's supposed to happen, like I said earlier, and recognize it when it doesn't happen. But I'm going to take it back to right to the beginning, like when this whole thing starts. It usually starts with a notice that you're going to be retrenched. So Kgomotso, I'm going to ask you here, what does a notice look like? And I'm asking this because people have said that they've received an SMS telling them that they're retrenched. They've received a WhatsApp telling them that they're retrenched. So in as far as understanding what a notice is and what the law says a notice is and should contain, what should people be looking out for when they receive a notice of retrenchment?
Okay, so the first thing is, the great thing about what Jermane did, pointing out the legislation, the wonderful thing about all of this legislation is that it's Googleable. You can literally go on Google and look for the Labor Relations Act.
Yes.
What we're talking about now is Section 189 of the Labor Relations Act, also fully Google, available online, really, really easy to find. And it will tell you what a notice should look like, a Section 189 notice should look like. What's really important is that a Section 189 notice is not a notice of retrenchment. It is a notice of contemplation of retrenchment. So it is from your employer to say, I'm thinking about retrenching you, or I'm thinking about retrenching people, some people in this workplace. Okay? I haven't decided. That is a genuine 189 notice, okay? It happens indeed. People will just say you're retrenched. That's not a lawful retrenchment. To notify someone today, don't come back to work ever again. Sorry, you're retrenched. That's not a lawful notice of retrenchment. The lawful process is that your employer must issue you with a notice of contemplation. Contemplation, I'm thinking about it. I'm considering it. I'm weighing up, okay? And in that notice, your employer should be telling you what, in essence, the underlying reason may be for the possibility of retrenchment. For example, it could be an economic reason. We are struggling, we're a restaurant, it's COVID-19, we've had to close, we're losing money, we're thinking about retrenching. And the employer invites you to consult about different issues relating to the retrenchment. For example, the timing of the retrenchment, how many people are retrenched, how those people will be selected, what categories of workers are those people in, what kind of severance pay are they going to receive. So your notice, your Section 189 notice is a notice to say, we are thinking about retrenching. We invite you to consult with us as the employer as to the retrenchment will take place and who will, those sorts of details of the retrenchment. So that's really important. So it is not lawful for you to get an SMS Netsommer saying tomorrow, that's it, it's tickets. It's not a retrenchment.
And I'm guessing if a person was to come to the CCMA with a SMS or a WhatsApp saying, I got this SMS to retrench, would that then obviously then constitute some unfair dismissal because the employer has not followed any type of procedure?
So I'm not going to pronounce on the lawfulness of a general, like a general pronouncement on lawfulness or unlawfulness, but in essence, you know, if somebody comes to the CCMA with just an SMS, they are demonstrating that they were dismissed. The employer must then prove that they did everything that was in Section 189. So if an employee comes to the CCMA and says, I got this SMS that said I must not come back to work, okay? The employer is called upon to answer questions as to where's your Section 189 process? What happened? What did you do? 189. What did you do to have a lawful retrenchment? So that is the way it works. And I think we'll talk about those details a little bit more as we go along. But I often say to people, you know, if I give advice about retrenchments and dismissals, you have nothing to lose by going to the CCMA and making sure of what happened was lawful. The CCMA services are, so if you're looking at this situation and you're like, this doesn't feel right, something does not feel right, there's nothing that stops you from going and making a referral at the CCMA free of charge so that you know exactly what happened and whether it's lawful.
Yeah, and I'll just come back to what Kgomotso has said, that a 189 is not a retrenchment letter, because that's what a lot of people think. They receive it, they don't fight it, they say, oh my God, I have been retrenched, and that's it. Well, you need to recognize that that is a contemplation of retrenchment. You need to understand that the employer needs to give you the opportunity to consult with him, to have a discussion of how to possibly avoid retrenchments or how to postpone retrenchments, to discuss the issues that led to the retrenchments, to discuss who is going to be retrenched. It's not a matter of, I don't like you, you're out, I don't like you out. So guys, please understand that once you receive your Section 189 notice, it does not mean that on that day you are officially dismissed. It's just the beginning of a process. All right. One of the next questions that we have, okay. We have a question here that says, I work for a small company. We were retrenched during the lockdown. Did the employee have to consult with us? We're only 2 employees. So I'm guessing the S question is, does consultation mean the same for everybody? Does it mean the same when you have 100 employees, when you have 10 employees, when you have 2 employees?
Can I take that one?
Does the employer have to do this? Is the employer expected? Yeah, sure, Jermaine, you can have that.
Normally, in an ideal situation is that the unions do these things on your behalf to be able to, the consultation process, the negotiation starting to take place, all those things happen when you're a union. However, if there isn't a union in place, the Act expressly states there that you can have a representative from one of the normal workers to speak on all of your behalf. And also to add to that is that these notices have to be in writing so that you can you can take your own time to read through the notices and hear what the stipulations are, what are the reasons they're retrenching. They have to give all those. That's why things have to be in writing. For any eventuality to take place, you know you have something to fall back in. Sometimes, these things always doesn't happen. And
Guys.
Yeah.
My next question is this: we're talking about, when we talk about unions, when we talk about employee reps, we're talking about places where employees can actually come together, stand together, and have a conversation together with the employer. What would happen in a situation, say, with a domestic worker? There's a lot of domestic workers right now who haven't been able to go back to work. There's a lot of confusion. I mean, people want their domestic workers to come back in level 3. People's salaries have been cut, so they're not able to pay their domestic workers. Would retrenchment look the same for a domestic worker as it would for, let's say, a more formally employed employee?
Well, no, not really. Ideally, a retrenchment speaks to a number of people, of a set amount of people. However, and you must remember, with retrenchment, there come certain things that need to take place, like, for example, severance pay and all other things that come from Section 189. However, with retrenchment, the reason for termination ideally would not really be retrenchment. It could be the expiring of the contract. That is how you could properly phrase it. So retrenchment is not, as a general rule, retrenchment is there for a specific purpose, a specific criteria that take place. So as your example you use for the domestic worker, retrenchment will not be a suitable reason for termination for that. But maybe Kgomotso can also weigh in on that one as well.
Yeah, I have seen retrenchments, dismissal for operational requirements for domestic workers. It doesn't look the same. So it's not something where you're going to have a mass consultation and a mass meeting and all of these things, but it's more of a discussion with the domestic worker to say, look, these are my circumstances. Can we talk? So for example, you may have a worker who works 5 days a week, right? And maybe you're paying her 7,000 rands a month or something like that. Right? Now, your discussion is much more to say, I really can't afford 5 days, but I can afford 2 days. Have to take your salary down to the minimum wage. That's what I can do for now. Alternatively, I'd have to talk about things like dismissal for operational requirements. But what I'm saying is, your consultation or the crux of your consultation with the domestic worker is to say, I'm considering this, but are there ways around it? Are there ways to deal with this before we retrench? That's the type of consultation you're having. Are you willing to take less money? Are you willing to work less days? So that we can see, rather not to dismiss you, but to instead lessen the time you work, lessen how much you cost me as an individual. So that is a possibility, but obviously practically it looks quite different. You're not going to have 15 consultations. You likelihood you're going to have, it's more of an informal conversation, but it should be documented and it should be in writing and all the same, because that same domestic worker, if her dismissal is not fair, she should be able to see what and be able to refer that matter to the CCMA.
Mm. Well, you just, Kgomotso, you just mentioned now with if she were to, the conversation between her and her employer about moving from 5 days to 2 days and then the salary going down. So that in essence for me is a consultation with your employer. I mean, I understand that it's a one-on-one situation where you don't have 50 employees or whatever, but it's still a consultation where your employer has actually is advising you of the alternatives that are available to you in as opposed to you actually getting retrenched. So when it comes to larger retrenchments in a formal company, is the employer obliged to disclose all the alternatives that they've considered with the affected employees?
Yes, so the employer must, in the 189 letter, the employer must already say the things that they've considered, that they've talked about. That will also be part of the consultation to say, well, why didn't that alternative work? Why didn't this work? So it is on the employer also to disclose in the 189 to say, we've already thought about this and this and this and this measure before retrenchment. And now we're here. This appears to be our last resort, but it's really, it's very important that people understand these letters to be invitations to consult. So basically, the employer is disclosing. I mean, even when you end up in litigation, oftentimes things like the financial statements of the business will come into play. If an employer, for example, says we couldn't afford this and this and this, you might say that's not true. It appears as though you have money or whatever the case may be. All of that information, it's very important. Sometimes people have even gone to court to force employers to disclose information during these very big retrenchments at these very big organizations. So information is very important during the retrenchment process.
And obviously, Jermane here, obviously TERS comes into play. Employers are claiming, they're claiming retrenchment because of COVID, because of financial distress. And I know you speak about this every time we have these webinars, but I mean, we still have instances where some employers really are struggling to get money from TERS, either because they haven't been able to provide all the documentation required, or they were in a position where they were not actually contributing to TERS. And recently, I think day before yesterday, there was the directive that came out that said that employees will now be able to claim TERS even if they were not registered with the UIF. So please talk us through some of, that new directive, because I think it's going to bring relief for a lot of people. And also just in general, when employers are talking about retrenchment, should one of the things that, especially in this Corona times, is one of the things that they should have considered TERS?
Yeah, the one thing I also want to add to what Kgomotso is saying before I get into that is that with large-scale retrenchments, another beautiful thing in terms of the legislation, there's two parts to the section 198. There's a section 198 capital A, which means now that there's new measures that can kick in for things to be a little bit more better in terms of the transparency. So which means that now it will be required for more than 50 people, that it will be considered as a large-scale retrenchment. And then now the nice thing is people like Kgomotso as a CCMA commissioner can come in as a facilitator to be able to deal with between the unions and the employer to be able to negotiate, come together, come with suggestions with regards to that. So the legislation is clear with regards to there is something called the section 198 retrenchment, which is normally a small scale retrenchment, and then there's a specific type of retrenchment, which is called a section 198 capital A retrenchment, where all the other measures now can kick in. And these things are nicely built into the legislation for safeguards, for things to be accessed, for the transition of things to move smoothly. However, coming back to your question with regards to TERS, I read the directive. It was introduced, I think was it the 20th? Yeah, the 20th. It came into the 20th of May. It's actually brand new directive, stating that they've included new definition. The word employee is taken out now. They've used the word worker in terms of that. So worker implies that it could be literally, sometimes employers harp on the issue of employee, but it's not an employee. or whatever the case may be, they'll hop on the definition. But now the legislation is, the directive is clear, and they expressly use the word workers. So you can be covered under this directive in terms of that. And they have made available now for the employee to claim specifically for the fact that employers have been unscrupulous with the whole situation. They have not paid the people. So now they've made this things a little bit more easy for employers to claim on their own online and using the normal U-filing platform that has been there. But however, they built U-filing and TERS together in terms of the application process. The only thing, however, now that you will need for that is obviously the supporting documents from your employer in order for you to do your own application. And the reason for that is because the money will come into your account now, no longer the employer's account, because these are the massive volumes of disputes coming to the Department of Labor and to the CCMA. And there's a whole new kettle of fish that needs to be dealt with now, because the Department of Labor has worked on an issue of trust between yourself as a Department of Labor, the triangular relationship between labor, employer, and employee. Now, the employer is obviously now, I'm not saying all employees, but there is a narrative and a perception now that the employer is being unscrupulous. And of course, now that's what they made to say that, look, we'll make this new system available for them, for the employee to apply for the TERS themselves, so we can pay the money in their accounts. Now, previously, there was not any availability for the employee to do it themselves. They had to rely on the employer. And that's why they've built this new platform.
I see we have a question that's come in live from Facebook, but before we go there, is it not a game changer that the directive now says worker and not employee? And does that mean that independent contractors might be able to claim? Because now, once you get out of the definition of employee and you're bringing in workers, how will that work?
Look, the word worker is a new thing. Eh? It stemmed actually from this new thing about worker. I've seen it before. And the last time I've seen that was when they expressly, look, I'll show you the Basic Conditions of Employment Act. Together with the Basic Conditions of Employment, there's a National Minimum Wage Act. Now, it is the National Minimum Wage Act has been incorporated into the Basic Conditions of Employment Act. So the definition of worker is in this act in terms of the National Minimum Wage Act. And that's why I think they have the directive stemming from this piece of legislation and brought into the COVID-19 thing, you see. But still, an independent contractor is excluded from the legislation. Okay. You will not be able to have any labor rights, nor will you be able to claim UIF. So unfortunately for you as an independent contractor, you won't be able to access anything in terms of those benefits. However, in terms of the Labor Relations Act, there's a section that talks here about Section 200 capital A in terms of who is deemed an employee. So even if, if you feel as an employee, if the employer has labeled you an independent contractor and you feel, but hang on a minute, I'm not an independent contractor. You saying I'm an independent contractor. I am an employee. I am deeming myself an employee. I'm going to the CCMA now and I'm going to test what you're saying, the validity of you, Mr. Employer, telling me that I am an independent contractor. Because the test, one of the tests is, are you regulating my working hours? Are you giving me tools of trade? All those things will be, I'm not going to go into detail on regards to that, but I mean, that can be tested at CCMA. And once you win your case and you are deemed to be an employee, then obviously all these benefits will come into play. The employer will have to comply and do all these things for you as an employee or worker.
I think that's important to know, because there's a lot of people who fall outside the definition of employee who should be protected by all this legislation, but are not, simply because of just how the contract that they happen to sign at the time. So let's go to Lee's question. Is the employer allowed to state on a retrenchment letter that you as an employee refuse the salary cut, hence the step of retrenchment has come into place? I'll give that to you, Kgomotso.
I saw this question, but it's neither here nor there. It doesn't really make a difference. So I mean, I don't see why an employer would put it on a letter. It doesn't harm the employee. It really doesn't make a difference. But maybe one thing worth noting is that if your employer offers you alternative employment, right? Reasonable alternative employment within the company, they may have grounds to not pay you severance pay later if you refuse that alternative employment. So that would be the only thing worth mentioning in relation to refusal of something. But there's no value in an employer putting on a letter that you refused a salary cut, and there's also nothing that it does not harm the employee in any way for it to be on a letter that you refuse a salary cut. It doesn't make it, and it won't affect your case going forward if you choose to litigate or if you choose to go to the CCMA.
Okay. We have quite a few questions. Another one is, what happens if a company closes down because of no more money? That's obviously, operational economic reasons. The company shut down. It is what it is. The only thing the employer will have to do is pay you your severance, pay you the money that they owe you. Because I mean, even in consulting, the business is closed, unless you guys have another take.
Well, remember, you'd have to go through formal liquidation processes. Yes. And then your employees then become part of this batch of creditors that the business owes money to. And they might owe you outstanding wages, they might owe you severance pay, they might owe you leave pay, they might owe you all those things, but you now are on a list of creditors that the company owes money to. They could be somebody that maybe they hired a building from, vehicle, equipment, whatever the case may be. So you become part of this batch of people that the company owes money to, and there's an order in terms of insolvency law where you are, who is paid first and all of that. It is, if a company liquidates, a whole other regime of law comes into play. Now we're dealing with insolvency law. So it's not only labor, it's not clear cut. You cannot demand today, I want my severance pay right now. You become part of the creditors that the company owes money to.
I think in that situation, also understanding that once you get out of that and you enter insolvency, you as an employee, unfortunately, might not be at the top of that list. A lot of times it's the bank that's at the top of that list, and the bank is coming for all their money. And unfortunately, sometimes when in a liquidation, as an employee, unfortunately, you might leave with nothing. So it's worth noting that when a business is going down and there's a list of creditors, a list of people that the business owes money, you might not be at the top of that list.
Or they might limit what you get. Maybe you'll get 20 cents on the rand for what you owe. So all of those, that's a whole different other area of law. So it's not as clear cut. Then business is still open.
Okay, we've got another question here. It says, currently I received a letter of consultation scheduled for tomorrow. According to the letter, they say they're using the FILO method. I'm guessing that's first in, last out. I was last one to get hired. It means I will be retrenched if the decision to retrench employees. The thing is, we are earning commission. I make my own salary, so why the retrenchment? Last in, first out. I think they meant to say last in, first out, not first in, last out.
Sorry. Yeah, I mean, I really can't speak to why they chose that particular method or why you may be in a category of proposed people to be retrenched. I mean, I can't say why they would choose that. Last in, first out, I hope you mean last in, first out, is a fairly common category of, it's a fairly common selection criterion for retrenchment, where they would look at the people who came into the business most recently and retrenching them first over people who've been there for a very, very long time. It is one type of selection criteria. It's not the only available selection criteria, but again, just to reiterate what Grace said earlier, receiving a notice of retrenchment does not a definite that you'll be retrenched. It's not a definite. It is a notice. Now you've got this consultation. So I think what you want to do in terms of preparation for your consultation is really consider and maybe write down for yourself things that you would say, for example, would be in your favor. For example, you talked about how you bring in your own money, you work on commission. You might want to highlight to the employer to say, I'm not sure why it should be me, considering I'm actually not, I don't cost you anything. I make my own income and actually I generate the business much more, or whatever the case may be. So right now, it might be a moment where you consider what you're going to put forward to your employer to say, I don't think it should be me. I don't know who it should be, but these are the reasons why it might be good for me to stay. I don't cost the company that much money. And I'm actually generating my own income, my own salary through the work that I do, or whatever the case may be. So that's where you want to be now. Receiving a 189 notice is not a guarantee that you will be retrenched.
Yeah, I think this one, I want to bring in the concept of bumping, where you said now, I bring in my own money, I'm an asset to the company. Can you, in doing that, say me and you, Kgomotso, or me, you and Jermane we're about to get retrenched. And I come in and I say, actually, you should get rid of Kgomotso because I think I work more than her, I work better than her. Can I, as an employee, come and make suggestions and say that I actually think I would be a better fit if you kept me, and I would be of more value to this organization as opposed to my colleague? And I think you should get rid of them.
So this is exactly why we have collective bargaining in this country. so that it's not some guys in the corner engaging and talking about their own stuff and making their own quiet secret agreements. That's what we don't want. And that's exactly what collective bargaining aims to guard against. To try and have a collective voice to say, none of us want to be retrenched. What can we all do to contribute towards this pool or take less from the pool so that we all stay employed? It's just a bit dodgy. Like, I mean, you know, whatever you want in life, but I mean, it's a bit dodgy to sort of sell your colleagues out like that. But that's why, and also anyway, even if you group together as a group of employees, there's no trade union, right? Let's imagine there's no union. If you group together, a much stronger voice, and you can then brainstorm and say, what can we do? What is money? What's possible? What's not possible? And try and bring consensus, come with consensus to your employer. Otherwise, your employer is going to be deeply frustrated listening to 45 different suggestions about what should be happening, how they should do retrenchment. It's better to do things with one voice. That's my opinion.
To be honest, divide and conquer has worked since the beginning of time. If you guys are not united, your employer is going to use that against you. And half the time, this is not a legal opinion. But half the time, you might be seen as the person who causes trouble and might just get yourself into some trouble. We have another question here from Marilise Minnie. She says that when we received the notice of retrenchment, so she's going through exactly what we're talking about. When we received the notice of retrenchment prior to even consultation, it already stated that the day of retrenchment. So the consultation stated that on the 30th of May, you guys will be retrenched. Yeah, last day of work. The people chosen to stay had already been selected as well and was already informed prior to us even getting the notice. So clearly some people had already been informed beforehand that you're staying and you're going. Consultation never took place and we never received any paperwork or retrenchment letter after that. That was the last of communication. Is that enough to state that we have been retrenched? That's a difficult one.
Well, I mean, look, if you're dismissed, you're dismissed. It doesn't make the dismissal fair. So if your employer dismisses you, you know, that it is what it is, and then you'll have an opportunity to go to the CCMA to say, actually, I believe my dismissal to be unfair. I believe this retrenchment is fair. And one of the things you may want to say is, the reason I think it's unfair is because I don't think consultation was genuine. It appears as though the employer had already decided when to retrench, who to retrench, long before we got correspondence on the retrenchment. And that's very important for labor relations, that Section 189 consultation be genuine, and not just something that people do as a formality. It really has to be genuine consultation. And one of the things that you may be able to say if you lodge a dispute is to say, I don't believe consultation was genuine because it appears as though they had already made a decision. So I think that's what I would say in response.
Marilisa, I hope you got that. You basically need to, if you decided, like Kgomotso said, if you decided to go to the CCMA, you could actually go there and say that these guys already decided. I stood no chance. I never had an opportunity to present my case. I never had an opportunity to present an alternative. I never even had the opportunity to say, I'll work less hours, I'll work less days. All of that had been decided beforehand. And even the time of dismissal, the date of dismissal had already been decided beforehand. So if you chose to go to the CCMA, those are some of the things that you would be able to present in your favor. Okay. Okay. I got a question here. When it comes to, I know we haven't gone to the CCMA yet, and that was the main reason for today's session. But there's a lot of things that happen before you actually go there. So we're just going to touch on a lot of those. I have a question here. If I suggested a demotion or a pay cut, so this is you consulting so that you don't get retrenched, to help save money for the business instead of retrenchment, can I ask for my old position or full salary once the business is fine? So I guess here the question is, if you as an employee make certain concessions in an effort to avoid retrenchment, and things eventually pick up, like say it was because of economic reasons why the employer was contemplating retrenchment in the first place. So you take a demotion because some money is better than no money. What rights do you have to sort of go back to the employer after things seem to have picked up to say, okay, can we maybe now revisit the old position as it seems as if the business has recovered?
Yes, you can. Can I take that one? I'm sorry.
Yes, of course, yeah.
Okay. You can. It's very much possible, and that also speaks to the consultation process as well, actually. To indicate to the employer, look, if business taking, would you be able to consider me? And of course, the employer would be obliged to take you because you have institutional memory in the company. You know how things work. The employer doesn't need to train you, so of course you will be able to take you back. A very nice thing also, I stumbled something also in terms of the LRA with Section 108, is that if you've been retrenched, just bear with me. If you've been retrenched, and the employer has taken you back within 12 months of employment, then your previous employment period still in place. So which means if you had 10 years service in the company, you've been retrenched, and however, in 9 months' time, it takes you back, all your benefits, all your things stay the same. Your years of service stay exactly the same in terms of the RA. You see, so which means that's a nice thing. But however, if after 12 months, then obviously you have a new start date and you have a new employment period. Another case, I've recently read up a case with regards to SAA. Remember, SAA had a massive retrenchment now recently.
Yes.
I'm following that case at the moment. Last week, the Labour Court has found that retrenchment was completely unfair. So it means that there's now an example for you as an employer to state that, look, sometimes the retrenchment takes place, there is avenues and ways for you to retrench it. In that SAA case, so which means that everything has to start over again now. Even though there was a facilitator, the court found that whole process was completely unfair. So back to the drawing board. So these things do happen. Yeah.
I think the biggest takeaway from that, Jermane, is that people need to be brave enough to go to the CCMA to check if everything is the way that it should be. And that's what you also said earlier, Kgomotso. People are scared. People are scared to go and find out if their employer is in the wrong or if they're in the wrong. It's just better to know and better to understand where you stand with your rights. But that's not a legal question. That's you having the bravery to stand up and figure some things out on your own. So thank you so much. Thank you so much for that, guys. We have a lot of questions coming in. This one is from, I'm not going to say names because I don't know if people want to stay anonymous or not. So the question is, once at CCMA, what would they do and possibly employer may not appear? So I guess here someone is asking for, I guess you've already referred the matter and now you're at CCMA and you're sitting in front of the commissioner. I guess the question is, what will the CCMA do for me?
Okay, so this is, I'm going to try and make this succinct, but it's a little bit long. But okay, so the main thing, you've made your referral, okay? How do you make your referral at the CCMA? Now do online referrals. The form you're going to complete is called a 7.11 form. Okay? Writes this down. So you do a 711 form to make your referral, and then the CCMA will eventually send you a date for your ConOb process, okay? So ConOb is, this is what happens at the CCMA. The day you arrive at the CCMA, what happens? Now you've long made your referral, maybe a month ago, your case has a date, okay? So you arrive for what you call ConOb. ConOb is a two-stage process. So what is conciliation? Conciliation is a very informal, off-the-record process, okay, where the commissioner will try and facilitate discussion between you and your employer. I'll get to where the employer doesn't show up, I'll get there. But let's say your employer is there. So the commissioner will facilitate a very sort of informal discussion to try and achieve settlement of the dispute. Settlement can look very different. Settlement could be your employer agreeing to take you back to work. Settlement could be your employer saying, you know what, let's pay this person 2-3 months salary so that this case closes today, as a carrying on for a very long time, right? Settlement could look like different things. Settlement could also mean, okay, come back to work, but we can only give you a lower position at work. Are you willing to take it? Okay, so settlement is different. If you do not settle the dispute through conciliation, you move immediately into what we call arbitration, okay? Arbitration is more formal, it's on the record, and the commissioner will record the arbitration process. Arbitration is like mini court, so it's your very it's your very own. What's that case? I even forgot what this big thing we're doing now, the inquiry, not arms deal. State capture.
Hey, wait, state capture.
I even forgot state capture was a thing.
Commission of inquiry.
Your very own little commission of inquiry. Okay, so if you can imagine it like that, you sit there, the commissioner will sit down and record, and you give evidence to say, this is what happened on this day. I was here. This is what I was wearing today. Everything that happened, you give your evidence under oath. Okay, and your employer will give evidence. You could bring witnesses with you, other colleagues, people who were there. Your employer may also bring witnesses, and they will give evidence. It's hectic. It's hectic. That's why it's actually
all those things. Yeah.
It's very great. It's very great if you could settle the dispute in conciliation, because it's speedy and you're out there in an hour and it's done. Arbitration is lengthy, and it can be very, very emotionally taxing. Sometimes people want to bring lawyers, but generally speaking, the CCMA does not allow lawyers, generally speaking, unless you apply. So after the arbitration is done, which could be one day, it could also be a week, depending on what happened. Could be 3 months, depending on exactly what happened. With these big retrenchments, it can be a long time. At the end of the arbitration, within 14 days of the end, the commissioner will produce what is called an arbitration award which is like your very own little judgment, okay? It's a little judgment where the commissioner says, this is what the law says, this is what happened to Kgomotso, and this is what was lawful or not lawful, the dismissal was fair or it was not fair, and this is what I award. Kgomotso must go back to work, or she must be paid 4 months compensation for this dismissal, whatever the case may be that the commissioner decides. So those are the things that actually happen at the CCMA. On the last thing about whether or not the employer comes to the hearing, if your employer does not show up, the arbitration will proceed with or without them in default, okay? Unless they have notified the commission that they don't want things to proceed. There's a bit of a process that happens there where they say they don't want arbitration to happen immediately after. But in ordinary circumstances where they have not given that notice, the arbitration will proceed without them, which means they have their evidence or their side of the story to say, this is what we say, or this is what we think. It'll only be your side of the story that the commissioner hears. So you, well, don't worry about what they do. You show up.
But no, I hear you. Is that the same for conciliation if the employer doesn't show up?
So if the employer, conciliation, remember, ideally conciliation and arbitration happen on the same day.
Yeah.
But either party is allowed to, before, object to arbitration proceeding immediately after conciliation fails, okay? So either you as the employee or the employer can say, we don't want arbitration to happen on the same day, please set it down for another day. So if your employer does that objection, it's a notice of objection, and they up, the conciliation will just be you and the commissioner chit-chatting and you explaining the process. The commissioner will explain the process and what has happened, but they will not proceed to arbitration. That will happen on a separate day.
Guys, let me tell you what I got from what Kgomotso said. This thing is lit, hey? This thing does not just happen. This thing requires time, requires money, and when you're busy up and down, it's your money, it's transport, it's emotionally taxing, it's you dealing with it's a lot. I mean, it's a lot. So when you make these decisions, it's a lot. And when you make these decisions, you need to be mentally, emotionally prepared, and even financially prepared, because when we say you must show up, which means that you must have transport money to go to the CCMA, you know? I mean, not all of us are in the same boat, but not everyone is privileged enough to have to go multiple times to go and attend some of these things. So these are things that you need to think about. You need to think about the fact that if the conciliation, how long do you want this thing to drag out? How many more times, how much longer do you want to keep having the same conversation? And do you have the strength, if you were to go into arbitration, do you have the witnesses? Do you have your story? Do you know how you're going to defend yourself? You know, these are decisions that you don't make lightly, because I mean, the employer is going to come guns blazing. They're going to come, a lot of times they come with their lawyers. I mean, even if it's an employer who only has 2-3 people, they're likely to come with a lawyer. Are you ready for some of these things that would happen to you? I am not discouraging not going to the CCMA. Please don't get me wrong. I am a firm believer of the CCMA. I am a firm believer of the work that they do. I'm a firm believer of it being a place where commissioners genuinely have the best interests of employees and employers at heart. But at the end of the day, it's about fairness. If you can look at yourself and understand that the situation that happened to you was not fair, and you have the evidence, you have witnesses, even if you don't, go and find out. You don't know unless you try. But yeah.
Can I just jump in? Can I just jump in? What's really important is evidence. A lot of the times, so whilst many of you are currently employed and possibly facing dismissal, it's very important to collect documentation and evidence. Everything that you, that section 189 letter, any emails between you and your employer talking about the retrenchment, anything that relates to your employment, your tenure at that company, or your dismissal, collect it, keep it in a folder, just keep everything with you. Make sure you've got all that relevant documentation. That's the first thing. The second thing is, a lot of employees get to the CCMA and will have conspiracy theories.
Yes.
This guy hated me. He's been hating me for 15 years. He hated me. So people will come and say stuff like that. You don't have any evidence. You don't know that. You don't know that this person hated you. You've got no idea. So,
I need to go off camera. I can't do
no, but it's very, look, indeed, your employer might hate your guts. It's true, but you can't prove that relates to the dismissal. So try and separate things for yourself in your mind early on to say, what is a real thing that I can demonstrate, and what is eating me up in my heart? Yes, this thing makes me uncomfortable. Many people come to the CCMA with allegations of racism, sexism, homophobia, a lot of things, and those things might very well be happening, but they're not easy to prove. Sometimes you say, what are the facts on the table? What actually happened? What is clearly wrong that I can talk to the commissioner about? I might be able to mention these things to the commissioner, but what I'm trying to say is that you're not going to be able to hit your whole case to the conspiracy theory that one manager hated your guy. It's not something that you're going to be able to hit your whole case to. So focus on things you can demonstrate.
Stick to the facts. Find facts and stick to the facts. I guess in law, that's all the law is about. If you can prove your position, then you have a case. But like Kgomotso said, people come, look, I've worked for a difficult boss. I know what that's about. But you can't bring your emotions into it, because I feel like that's one of the quickest ways to lose, because then your mind is all over the place and you struggle to put the facts together. Like Kgomotso said, write it down in sequence, so that when things get heated, when you're in front of the commissioner, you have your notes to refer to and to bring the conversation back. So thank you so much for stressing the need for evidence, because if you don't, then you're just here to tell us a story. It might not be a nice story, but it's just a story.
One thing I also want to add is that I like what you said, Grace, is that people must be able to, mustn't be scared to go to the CCMA. See, I know if you're an employee for the very first time go to CCMA, it's very daunting. It's not easy. But feel that you've been really treated unfairly. However, commissioners are there to also help you. Actually, as much as it's an unbiased approach between employers and employees, if the commissioner will also explain to you the process. If you don't understand, you'll even get an interpreter to feel safe. These guys are well trained to work with any type of person. So I wouldn't discourage anybody. I'm glad what you mentioned earlier on about the CCMA, Grace, because. If the employer comes there with these lawyers, you don't even have to worry. The commissioner will pick up on that, and he will protect you if you need protection. The commissioners are there's a thing called comparative ability. He will compare your ability in terms of your knowledge, and the employer coming to these lawyers. Kgomotso will protect you in that hearing. You don't have to worry. So I would encourage you, go to the CCMA.
But they're gonna come find you.
They will protect you. Don't worry. Go. I always encourage people to exercise their rights. And once you win your, you know what, you feel like $1 million. You know what? I've achieved this thing against this mighty whatever employer or company.
No, it's true. It's true. It's true what you're saying, Jermane. It's a David and Goliath story. If you stand up for yourself, let's say if you don't stand up for yourself, you will never know if you were wrong or you were right, and you'll go through life, not go through life. Let me actually stop. Let me move on to the next question. Let me do that. So would an employee be in a position to enter into an agreement listing the measures that shall be implemented, which shall be reversed when conditions return to what they were prior to the challenges which arose as a result of the pandemic? Would the agreement be of value to the CCMA? In what I'm understanding from this question is similar to what I had asked earlier, where you accept your terms of your employment to be changed to something less favorable in order for you to avoid retrenchment, and enter into that agreement. So from this, the employer is obviously seeking for your written agreement if they're making you sign, and then where the agreement says that the conditions will revert back to what they were once things are back to normal. And then the thing is, would that agreement be of value before the CCMA?
Is this for me?
That's for you, Kgomotso. CCMA is all
but I
you.
think, yeah, but I think I mean, definitely any information relating to the retrenchment is of value to the CCMA. But I answer in the sense that it might render the dismissal fair or unfair necessarily. But I mean, I think it's quite similar to the question that was asked earlier about, like you were saying, asked earlier about changing your conditions of employment and then going back. But it is a good to go there and say the employer. So actually, yeah. So I'm imagining a circumstance where an employee comes and says, I have this agreement where they said they would take me back. I'm not sure what a commissioner would then do. Enforce that agreement now? Am I misunderstanding the question?
I guess, honestly, I don't know what the context is. Maybe Anonymous would like to ask us their question themselves, because I guess in this situation, they may be thinking of signing the agreement to the lesser terms. And then I don't know if it's going to explicitly state in that agreement that when things pick up, that they will revert back to their old terms. But I mean, if it's because of economic reasons, when will that be? I mean, people don't know.
Even if there's an agreement to say, where in 12 months time, if things pick up, we'll take you back or whatever the case may be, it doesn't mean that the retrenchment was fair.
Yeah.
It's not something, even if there is such an agreement in relation to the retrenchment, it doesn't make the retrenchment fair. So it's still that you can refer to the CCMA to say, I still don't believe this was fair. There's no commission who would say to you, wait for 12 months and then come back. No, they're not going to say that. They're going to look at what happened in the retrenchment, whether or not agreement about, because there's many retrenchments like that, where they agree to say, should things pick up, these are the first employees that we'll call to come back, for example, So it's not that it renders the retrenchment fair. But maybe this person is asking if they are still employed, so they've not been dismissed.
What would be different?
I'm imagining a circumstance where you agree to be demoted, for example, and you're trying to ascertain whether that agreement to be demoted is fair.
Yeah.
So if you suspect an unfair labor practice that is happening within your organization, that is also something that can be referred to the CCMA. That is not necessarily a dismissal. You could think it might be an unfair labor practice. It can also be referred to the CCMA. It's not only when you are dismissed out of the company that you can go to the CCMA. Even if it's an ongoing thing that is bothering you, still employed, you can go to the CCMA and refer it as well.
Guys, you've heard that. You don't have to wait until you're out the door before you go to the CCMA. When things are wrong, and the CCMA, it goes back to what we said, go and ask, go and find out, because you don't know. You might be sitting there accepting things as they are, but if you go and find out, you might actually find out that you might have a case for unfair labor practice that you can then bring before a commissioner. We've got another question.
Demotion.
We've got another question here. This is also another person who's received a notification of retrenchment. However, they did not have the money to pay for the packages to be paid out to us. We then got notified via WhatsApp that we are instead on temporary layoff, no time period or anything. No consultation was done for retrenchment neither. What is our right to this temporary layoff? How long to wait around, and is any money due to us? So I'm guessing here the employer decided to retrench and then backtracked and said, actually, no, I'm not retrenching you because I don't have money to pay you your severance. So I'm going to notify you via WhatsApp that you are now on temporary layoff. No consultation about that. And then no consultation neither. What is our right in this temporary layoff, and how long do we have to wait around, and is there any money due to us?
I think Jermane should take this one because this temporary layoff thing, even for me, I'm like,
It's a tricky one. It's a tricky
Yeah.
one. And also, I think there's something to be said about the employer first making the decision to retrench and then retracting that decision via WhatsApp and then literally sending out new communication to say that you're not retrenched anymore, you're on temporary layoff.
I also, just before Jermane comes in, I've seen, you know, there's a lot of things, there's a lot of disguised dismissals. A lot of the time people will come to the CCMA and say, my employer said they'll call me after a month, and then they never get called. They even refer their cases late because this person has never called them back. They're dismissed.
Yeah.
Never been told they're dismissed. But yeah, I think maybe Jermane should jump in.
Yeah.
Okay. Well, a dismissal based on operational requirements, still a dismissal. The question needs to be asked, was it procedurally fair or was it substantively fair? Those are two questions the commissioner is going to be asking. So nothing stopping the employee to refer in that case. I would, in my view, I would refer the case. And yeah, what will the outcome of that be? However, another dynamic is that since the employer put you now on layoff, it's not unlawful to put you on layoff. You can, the employer has to put you on layoff. However, the dodgy part is that he first used retrenchment, then he backtracked, then he used a layoff scheme. But the relief, at least for layoff, in terms of the reduced time, the employer can apply for you for UIF for that time period, because the bottom line is to her question is there's no money coming in. That is the bone of contention of what she's grappling with at the moment.
There's no money.
She can compare the employer. Look, okay, yeah, you put me on a layoff. Can you apply for? Can you give us the UIF documents to apply then? Because in terms of the 2016 amendments for UIF, there is now a facility for you to be able to draw a reduced time UIF. Previously,
Even
it wasn't available.
Even TERS.
No, not TERS. Well, since that TERS is the direct impact of the business, so TERS could come in there, and after TERS, at a later stage, you could apply for the reduced time. However, you see, there's different. You see, by the Department of Labor, a reason for termination is very important. There's different reasons for termination, and there's some reason for termination that might not make you qualify for UIF. There's two, in fact, that make you not qualify for UIF. If you abscond, if you resign, those are reasons that you have indicated that terminated your own services or make you not to qualify for UIF. So which means that directive can only come from an employer. An employee cannot say, what is the reason why I'm terminated? So there's different reasons for termination. Now, we have already identified a few that she has mentioned. The first reason for termination was retrenchment. That was backtracked because of financial constraints. Second reason for termination could be reduced time or layoff, as they call it. Now, previously, you could not apply for UIF if you were on a layoff. You would just have to suck it up and stay at home. But I'm not aware of what the duration in terms of lawfulness. How long can a layoff take place? Maybe Kgomotso can just speak a little bit on that if you're aware of that. But what I do know is that the reduced time benefits is available for you as an employee. Consult your employer. Ask him, well, okay, you have put us on layoffs. Can you do TERS for us? And can you do reduced time? Can you choose one of them? I would rather advise that the employer do COVID-19 TERS for you, because since I hope she wasn't clear there. If the retrenchment was a direct impact of COVID-19, if it is, the employer is eligible to apply for COVID-19 TERS, yeah. So just put that in motion, yeah.
Yeah. Anonymous, I hope you got that. I hope that you understand that you're not retrenched, you're temporarily laid off because your employer retracted their retrenchment, and that as a result, and if this was as a result of COVID and economic circumstances, then they should actually apply for TERS. We said earlier that TERS is now available to all employees, even when their employer did not comply. All employees will now be eligible to claim TERS. So the employer can no longer run around, hide their head in the sand and say, well, I didn't comply, so you guys are just going to be left in the cold. With regards to consultation, you're not retrenched yet. I guess the temporary layoff was similar to what a lot of people are experiencing right now because of COVID, which is not necessarily wrong. How long are you going to wait around for? I guess it depends on which business this is. Obviously, you've seen how with the different levels, different businesses are opening at different places. So if you work in the restaurant industry, unfortunately, I think they're only going back in level 1. You didn't specify which industry you're in, but that's also going to determine when you say how long are you going to wait around for. That's something that I don't think we can answer you right now. Is there any money due to you? The money that will be due to you is the COVID TERS, or your employer would have to go and apply for reduced working hours at the CCMA. So your employer does have the capacity to do.
Sorry, just to make clear, it's at labor, but this is also UF related, so it's Department of Labor.
Department of
Labor.
Yes.
My fault.
So I hope you got that, Anonymous. So yes, there is money due to you. Your employer should apply. There is specific instances where the employees can apply. And Jermane, do you want to just speak to those while I find the next questions?
Okay.
I know you spoke about them earlier, but just to run through them one more time.
Which questions? The one we've dealt with now?
No, I think there was a directive where I saw that there were three very specific circumstances that allowed employees to go and claim TERS. And I think one of them was where they could prove that their employer did not apply on their behalf.
Yes. Okay. Yes. Well, on the U-filing system, there is a place where you can type in your ID number and see what amount, first of all, there's a section where you can see all the listed companies that has applied. It's in alphabetical order, so you just type in, it will automatically just jump up to the letters that you put in terms of the companies. And then second of all is that you can check whether your company has applied. You see the name there. Okay, fine, the company that applied. The next thing you can do now is you can check what amount was allocated to you in the event that the employer has applied for you. So if you see an amount of 6,002 Rand, that amount must reflect in your bank account. In fact, it's supposed to only take 2 days for the money to come to you. If you see the employer has taken any money from that, that is completely unlawful. There is no tax deductibility from UIF. It's a normal statutory deduction, like pay as you earn, like tax, and UIF is also a statutory deduction. There can't be a deduction from a deduction. So there's no way they can do that.
Okay.
So if that happens, I would suggest that you report this matter to the Department of Labor. The Department of Labor is going to be starting operating from the 1st of June. This information is not really out in the public. So if you cutting edge information from us, so you probably know information from us. So yeah, the Department of Labor is opening on the 1st of June, and they are going, that's now coming Monday, and you can be able to lodge a complaint there, or you can use the Impimpa hotline, because I anticipate that they're also going to be extremely busy and full. They're going to be full, chock-a-block full. So I would rather I suggest that you do it online, or wake up 4 o'clock in the morning and go stand in the queue to lodge your case, because that's the reality of how things are crazy at the moment.
Yeah. No, Jermane, thank you so much for that inside information. You've heard it here first. Another big thing to remember is a lot of people are complaining that the money that's showing on their ID is not the money that they're receiving. So you've heard that if that's the money that's reflecting under your ID number, that's the money that's due to you. There's no deductions, there's no tax, because you can't do a deduction on a deduction. We have a question here, Kgomotso. This one is definitely yours because I got it on your page. So there's a company, the question is, there's a company that is forcing its employees who are over the age of 60 to retire, and it uses COVID as the basis for this. It's as a risk factor. However, before the outbreak, the general practice was to allow staff to work until they reach 65. It has therefore used COVID to change the established company practice, which was previously used as the basis to define the normal age of retirement at that company. It has issued letters to some of the employees unilaterally, no prior warning and discussions about these changes. Employees have just been given 1 month's notice.
Yeah, I did see this question and I attempted to answer. So, I mean, I'm not sure if there's any specific provisions, and I hope Jermane can actually come in. To me, a dismissal is a dismissal, and it can possibly be unfair, and it can possibly be referred to the CCMA to consider its fairness. I don't think so. So I don't think there's anything special that would apply to them claiming that it's because of early retirement all of a sudden. I don't think that I mean, the laws of the country that determine retirement age have not changed. So I don't, you know, if you're claiming that that's the reason for the dismissal and it's not a genuine reason for dismissal, to my mind, the question comes to unfairness, and the unfairness should be referred to the CCMA. But perhaps Jermane has another view in relation specifically to retirement, if there's another approach that the law takes that I'm not aware of.
Look, I think another dynamic, it could be in terms of Employment Equity Act. That's a form of discrimination. You can't discriminate based on age, race, sexual orientation, all those things. You can't. It's a listed ground, actually. So age is also a listed ground. So the burden of proof, if that employee goes to CCMA, the burden of proof lays with the employer, because it is a listed.
Yeah.
Be an element of discrimination there. However, the other thing is the in terms of COVID-19, the employer will probably argue like, look, in terms of the risk factor, this guy, I can't allow him to come back to work for whatever reason. So there's different dynamics at play. We don't know what the facts are that person will know, but that's also something that can be considered.
I feel like this one's a catch-22 almost. You know, they're not going back to work because it's a risk factor and they might die. And then on the other hand, it's a listed ground for discrimination. So I guess it's a question of what do you weigh up? It's a tough one. I don't even know how to summarize that one.
But I mean, discrimination, anytime you have discrimination and it's clear that there's discrimination, there could be grounds for limitation, you know, on section 36 of the, well, let me not go to the Constitution, but there could be grounds for limiting an individual's right to not be unfairly discriminated against. But I think the short answer it goes back to the reality of whether or not the dismissal is unfair. It amounts to a dismissal. So an employee can go and refer to the CCMA the way any employee who believes their dismissal to be unfair can.
Absolutely.
And I'll take it from my panelists. You heard it here. Go to the CCMA, refer the matter, because obviously then your commissioner will decide on the facts in front of them. We can't give you that answer right now, but go with the facts, go with the policy of the company. Possibly, I mean, not all 60, I mean, there's some 60-year-olds who are a lot healthier than I am. So it's one of those things. I digress. There's a guy at work who, this guy's like literally 65. You have a meeting with him. He doesn't eat anything. He doesn't drink anything. He doesn't go to the bathroom for 8 hours. I'm dying at the end of those. So not all 60-year-olds are the same. We have someone followed up on the question on retrenchment. I'm just going to read it out loud, but I think I can take this one. Follow-up question: retrenchment was retracted. They are receiving TERS. What happens after the TERS fund is finished? Can he go back to retrenchment? I believe the reason for retraction was because there was no money to pay severance, but also because they did not provide notices, etc. It's like they want to use this time to use as a notice. I'll take it, but I mean, please jump in, guys. From what I can understand, they're paying you. What's going to happen after TERS is finished? We don't know. TERS is supposed, Jermane, maybe you have more inside information, but from where I'm standing, I've heard that TERS is going to last for, this is the second month. There's one more month to go. That's what I saw in the directive. Anything more than that, the commissioner was talking about, they would be in real trouble in as far as being able to afford to pay out TERS, because I think we're sitting on what now, about 15, 16 billion rand. I don't know how long they can keep paying out that money. So I don't know what's going to happen after TERS. Can he go back to retrenchment? Yes. If you're not able to sustain your business after that, and your economic reasons are for retrenchment, he can, but he must follow the procedure that we have spoken about. There must be consultation. There must be procedures that are followed before you guys can just simply be retrenched. Your employer can't just wake up and decide, I'm going to retrench today, then it's temporary layoff, then it's back to retrenchments. You're playing with people's lives, so procedures and processes must be followed. But I can see Jermane is looking like he wants to add something to what I just said.
No, you put it out perfectly. It's fine. We all agree with that. I agree with that.
But I mean, it's true. I mean, after TERS, we don't know. We don't have endless pools of money. So I don't know what I don't know.
No. Look, the government has bent over backwards. They really tried their best, and to at least give you some relief measure. So after that, after 3 months, I would suggest rather start looking for work now already for something else. It's because I mean, it can only go on for so long because it come to a point when it's unsustainable. So yeah, that is what is available and next month, last month, and that's it.
Yeah, that's it. There's a question here. My employer is cutting our salary, but not reducing our hours. They say because we are getting TERS, they're not going to reduce our hours.
No.
Yeah.
That is completely like unfair. Why would you? The basic conditions of employment is clear. For services rendered, you must be remunerated for your time. There's no way they can say that. You see that those one of the employers think they're smart. They're not going to get away with those type of behavior. It's unscrupulous behavior, and once again demonstrated by them to be able to tell employees that if they can reduce your hours, but your salary is supposed to still stay the same.
Please tell the people where to go, because you guys tell me this every week, every time I forget to write it down. It's the 73 application to the CCMA for
Section 173A application at the CCMA. Remember now, when it comes to statutory monies, the Department of Labor and CCMA have concurrent jurisdiction in those cases. Now, previously, all statutory money claims was only dealt with at the Department of Labor. However, with the new amendments to the LRA, and in fact, when the national minimum wage came into effect, and in terms of and also together with the LRA, they have concurrent jurisdiction. So actually, you have a choice where you want to go to. For all statutory monies, you can either choose the CCMA or choose the Department of Labor. However, I would choose CCMA as my personal opinion, and as a person dealing with these every day. The Department of Labor has only so much capacity in terms of what they can handle. You will wait a long time for the inspector to go out to the employer to enforce that piece of legislation. A better option for you is to go to CCMA. There will be a con-ar process. You remember what she talked about earlier? Con mean conciliation, ar mean arbitration. So which means that possibly could take place in the same day, where you will wait months and months in the Department of Labor to lodge a case. So I would suggest.
And you can't postpone 73A. You can't do it on a separate day. It's all on the same day, no matter what. Yeah.
So this is how you see now. If you're on our page, that's how you learn all this information. So yeah, that's.
Guys, you heard it here first again. Maybe not first, but you heard it here. when you are owed for the hours that you work. Your employer cannot come and say, you're getting TERS, I don't need to pay you, but you're still gonna work your full 8 hours or your full 9 hours, but you're not getting paid. Guys, go to the CCMA. To be honest, I agree with Jermane. It's also I prefer going to the CCMA than going to the Labor Department, because a lot of times the people at the CCMA, they're extremely helpful. I've never gone there and someone is having a bad day. They walk you through the forms. They tell you exactly which forms. No, honestly, I have never really had a bad experience at the CCMA. And not to say anything bad about the Labor Department, but they are inundated with work. There's just too much going on at the Labor Department, and I don't blame them. I mean, every time you go to the Labor Department, Jermane is right, you wake up at 4 o'clock in the morning and you get there and you're not even the first person in the queue. So there's a lot that happens at the Labor Department. But CCMA, things are fast. Kgomotso said, with your Section 73, when it comes to your to monies that are owed to you, it happens on the same day. So it's something that you can take with you, finish it on that day, and take it back to your employer. Yeah, how does it work actually once you've done the 73 application?
So you either gonna have a settlement agreement emanating from the conciliation process, and remember, settlement agreements have the same force as court orders. Okay, so that means if you need to enforce it, you come back to the CCMA, and then they send the sheriff to your employer. And you know, you can joke with employers and say if they've got TVs, desks, whatever, they're gonna sell them to enforce that thing, to enforce the order.
They're gonna pay.
Yeah, so they will. The CCMA, all that enforcement can still happen within the CCMA, which makes it quite quick and efficient for workers to follow. If arbitration, then there will be an arbitration award after 14 days. Okay, deciding whether or not the employee is owed or not. And remember, when you go to the 73A, you must come there with your hours, and don't just get there and say they owe me 5,000.
Evidence. Yeah.
Somebody will get there and say they owe me 100,000. 100,000? Like, where did that come from? You need to be able to prove those hours. Like, this is my time. Yeah. This is when I work. This is how much each hour is worth. So you need to be able to your payslip, timesheets, all of that stuff to say this is my claim. An arbitration award, the commissioner will produce an award within 14 days of the actual arbitration, and that award also is now like an order, so you can enforce it against your employer if they don't pay.
Okay.
Another thing, something there, please, as well, that's very important, I feel, as well, is that if you have been dismissed, however, your employer still owes you your last salary. The employer said, look, I want you out of my premises, don't come back here again. But I've worked the whole month, you're telling me I must just go and I'm not going to get my money. What
You're
can happen?
That's not what you'd say. You'd have other words for them. But anyway, carry on.
Yeah. Yeah. But then what can happen is that they can do a consolidation of proceedings. That's now a Section 74 application. From terms of the LR, Section 74 of the Basic Conditions of Employment Act, consolidation of proceedings, where the CCMA commissioner will actually calculate, if he rules in your favor, what will happen is that he will calculate how much money you must receive in terms of, for the fact that you've been unfairly dismissed, how much money is that, and your outstanding all statutory money. That amount will be combined in your arbitration award, and you will sit with a chunk of money that will be due to you and enforceable. So make sure those things, we're telling this information so you can be aware of what your rights are in terms of you as there's many rights you have. That's why I would encourage you to get these pocketbook booklets. They're very helpful. You can open it literally anywhere and start reading anything by interesting. That's why I love for label. This is something that I'm passionate about, really.
Guys, the questions keep coming in. My employers are paying 40% and TERS is paying 60%. My employers still want me to work my normal hours. Is that correct? Yes, because you're earning 100% of your salary. Am I wrong? Yes.
Well, if you get 100% of your money, then obviously why do you think you deserve an extra 10% on 100%? If you're getting if it equates to the full amount of your salary, then obviously you don't qualify for anything. Unless though, if you earn 90% of your salary or even 95%, then only that applications can be made. But if you receive 100% of your money,
No.
then obviously you will.
I think I said that wrong. She's saying that her employer is paying 40% of the salary, and then TERS is topping up 60% of the salary. So the question that she's asking is, her employer still wants her to work her normal hours. Is that correct? And I'm saying yes, because you, in essence, are getting your full salary.
But now, what confuses, what puzzles me is that why is the employer claiming for the TERS if all your systems everything is operational as normal? Because your business is not directly impacted. If how are you negatively affected as an employer then? If you have to work 4 hours.
Yeah, you're not negatively affected.
Yeah.
Yeah.
So like, what is happening there? Maybe, can she ask the question? Maybe. Can Shepa put her on? We can hear what she has to say then. Oh, I don't know.
No, maybe it's a question of an employer who shouldn't have been applying for TERS and did.
There's a lot of those. There's a lot of those. I mean, my brother's salary was also cut 40%, and the employer applied for TERS to top them up, but he's working more hours than he usually did because he's working from home. But he's still expected to work his full hours because the employer is like, but you're still getting your whole salary. We have a question here. Oh, where did it go? We have a question here that says, for those who have been temporarily laid off, do you still accumulate your days during the months of the layoff, for example, leave? So we all know, okay, leave actually just accrues, I think it's 1 day for every 17 days or something like that. Mm-hmm. So the question becomes, we've been off work now for about 2 months. So would your leave be accruing in that time?
Because the act clearly states in terms of leave, for every 17 days worked, you accumulate 1 day. For every 17 hours worked, you accumulate 1 hour. So if you don't work, you can't accumulate anything. So you won't be able to get extra leave days or whatever the case may be, because you have to work. Just like you have to contribute for UIF in order for you to get UIF. So it's the same principle.
Sometimes it's not the answer you want to hear, but it's the answer that's there. We all plan for our leave days, but I think some of us, look, I don't think a lot of employers are actually going to force this thing. I don't think a lot of employers are going to take the leave days from employees, but we've seen a lot of employers, on the other hand, forcing employees to take their leave days until their leave days are exhausted, and then forcing them to take unpaid leave. So for this specific answer, if you don't work, you don't get the benefit. So you don't accrue the leave, which is the benefit. I think we have all our questions. This is the first time. Well, we've gone over time with 8 minutes. This is a record. We've gone over time by 8 minutes. I just want to say thank you to everyone who was with us here tonight.
There's a hand.
There's a hand. Where's the hand?
Am I imagining it? Or maybe it's gone.
Hand, please raise again.
The hand was there. I'm just not sure whose hand it was.
Oh,
no, maybe she asked. I think I know whose hand it was, and I see that her question is there, and we did answer it. So perhaps that's the end of it. Okay. Yeah.
You must live with knowledge, guys. Don't just walk away. Guys, thank you so much for doing this. This is always fun. I obviously want to start off my thank yous with Kgomotso and Jermane. Thank you so much for being with us here tonight. Thank you for answering your questions. Thank you for the great energy. This is always fun. Always. Thank you for everyone who's joined us for the webinar tonight. I hope you guys have learned something. My key takeaways for the night is that don't be afraid of going to the CCMA. Go and ask, because you will never know unless you ask. CCMA staff, CCMA prides itself on fairness, on efficiency. So do go, and the processes as the CCMA, you refer using the 7.11 form. There will be a con-op process that will probably happen on the same day. So remember what Kgomotso said, when it comes to the employer showing up, don't worry about them, worry about yourself. Kgomotso has something to say.
This is really important. Within 30 days of your dismissal.
Yes.
This is critical.
Refer your form within 30 days of dismissal. Otherwise, you're gonna have to get into us saying, sorry, I didn't know, but rather just do it within 30 days and get that done. There will be a con-op process. The con part is where it's an informal, you and the commissioner are just, vibing, you and your employer. So ideally, you want to resolve your issues there. However, if you get into the arbitration process, things start to get a bit lit. You need to bring your evidence. You need to have your story. You need to have your witnesses. You need to come prepared emotionally, psychologically, and possibly financially. But these are just things to think about. It doesn't mean that you don't go. It means that you stand up for yourself. It means that you find the courage to be brave, to face the David and Goliath, as Jermane had said earlier, and to stand up for your rights. When we spoke about notice with your section 189, remember, it doesn't mean that you are now immediately dismissed. It just means that it's an invitation that your employer is thinking about dismissal. They must tell you what alternatives they've thought about. They must tell you about the criteria for dismissing employees, and they must tell you how many people might be let go of. I think that's what I got. And you will be able to apply for unemployment UIF, which is separate from TERS, because now you are officially, you will be unemployed. So it'll be a whole different set of facts. If the business closes completely, remember, you are no longer in labor legislation, you enter into liquidation, and there will be a list of creditors. You might not be at the top of the list. So, and as far as you getting money out of the business, it's never a good place to be when the business is going through liquidation. So with that, before I close off completely and tell people where to find us on our socials, I'm gonna let Jermane go and tell us a little bit about him and all about labor law, and they must follow his page while following LUMA, and then Kgomotso will also tell us we'll also say goodbye.
Guys, for you guys who was watching and who was participated, it's important for you guys to familiarize yourself with the legislation, or whatever information. You just Google it, or you have your phone, just whatever question you have, find it there. At the end of the day, knowledge is power, and at the end, it's up to you to exercise your rights. Now, the employer can't discriminate against you or victimize you for exercising your rights, because at the end of the day, it's a professional setting. We will disagree in the workplace. It doesn't mean I don't like you, but if we disagree, I have my reasons to why I'm disagreeing with you. And if you're not going to help me, you must know, as an employer, I'm going to exercise my rights outside this company. It's not always necessary for you to go outside the company. You can be able to resolve this matter. Just say you're unhappy and give your reasons why, in a nice way, in a professional way. You'll find, to your surprise, that employers actually do listen to reason, and you might not even have to go to outside tribunals or third party to be able to resolve the matter. Because knowing your rights is fundamentally important at the end of the day. And if you have these pocket sizes, you will be able to know what your rights as an employee. And you can find, if you're struggling, you can find us on all things labor law or high LUMA law, and then we will be able to guide you or give you advice freely, of course. And then, yeah, so thank you very much, guys.
Not free for long, by the way. Well, this will always be free.
Yeah, you know what, guys? It's very, what we do here, it takes a lot of time, it takes a lot of effort, it takes money. So you are really privileged to have this platform to be able to talk to us. Chipo, I wanna publicly just like commend you for how you put this thing together, your posters, your notices, all the hard work behind the scenes we don't see here. It takes a lot of manpower, so I want to commend you, my brother, for what you do for us here on this platform. And thanks, Grace, thanks, Kgomotso, and we will see you again, hopefully again sometime. Thank you very much.
Thanks so much.
Check me out on All Things Labeler. You'll find all the information. And I also have a YouTube channel with the same name, All Things Labeler. So please tune in and engage us there. Thank you.
Yeah, no, my last word, but I want to reiterate actually what Jermane said about information and knowledge being power. You know, so often you get, you talk to domestic workers, security guards, they know exactly what's going on at the CCMA. They know exactly what their rights are. They know exactly how much severance pay they owed. You have 3, 4, 5 qualifications. You don't know what's going on. You can't open the legislation. So it's really, really important to start to see yourself and understand yourself within the reality of the space we're in. Things are difficult in the economy. All of us are at risk. All of us are at risk of being exploited as long as we're employees. That's a reality. So it's very, very important for you to know your story, know what you're, educate yourself, educate those around you. Really, really take the time to do that. And yeah, I'd just like to say thanks to everyone. This was great as usual. And you really can't find me anywhere. But yeah, you know.
You will find her right here.
I don't want to see you at the CCMA. I don't want to see you at the CCMA, but you can come and register for LLB at UJ.
Everyone is plugging. Everyone is plugging. Guys, thank you so much. Remember, be brave, be strong. I'll reiterate what my panelists have said. Knowledge is power. Educate yourself, educate those around you. Don't have too much pride to say, nah, I can't go to the CCMA. Hey, when things are rough, you must do what needs to be done. And, you know, stand up for your rights. People fought for these rights. We're here telling you about these rights. Do the right thing. Guys, thank you so much for being here. Chipo always tells me, go on Hi Luma Law, go on our Facebook page, like our page. Although there's only like 3 people on the webinar right now, I think everyone's gone home. But the 3 of you that are there, please go like.